Hello, IP friends. Welcome to episode 72 of IP Series Podcast with Rita Amori Chinda. Now, in my last episode, I talked about design right protection for fashion designers. And today's case study is like a blend of fashion, sports, and intellectual property. And trust me, guys, you are gonna love this. Now, if this is your first time listening to me, please check out the other 71 episode. From 2020 to 2022, that's a long time. But yeah, check out the previous episode for design right protection. And subscribe to my podcast as well and my newsletter. I always try to convert the podcast to newsletter depending on, the information I have available. But for my returning listeners, you guys are the best. Thank you guys. So this is a 3-part series. I'm going to start with the sports, fashion, and IP segment, and next up the broadcasting, and then I'm going to review a case that we currently need to pay attention to, especially those in the audiovisual space, the broadcasting space, sports industries. But let's delve into our conversation for today. So I had reviewed this case in 2019, December, sometime in December 2019, and this case features Dolce and Gabbana and the late Maradona. Now, it turns out that at the 2016 fashion show we held in Naples, Dolce and Gabbana, during their runway presentation, had a model that wore a sports jersey with Maradona. It's a white and blue jersey, anyways, which had the Maradona's name and his number 10 on the runway. And Diego Maradona wasn't having any of this because Dolce had said that it was like they were kind of paying homage to him, and he was like, nah. So he sued Dolce and Gabbana for €1 million. So that's like the summary of the case. Now, Diego Maradona wasn't just suing because they were using his name, and he sued them for using his name and his number without his permission, which would kind of give his own fans the impression that he went into a collaboration with Dolce and Gabbana. As we've seen, if you notice, a lot of celebrity kind of always want to go into collaborations with luxury brand or any fashion brand out there to create a limited number of collection, and just to encourage patronage and more access to the consumers and the market, and penetrating the market as well. So Diego Maradona was not having any of that. He was like, I do not want my fans thinking that I have endorsed this, and I gave my consent to Dolce and Gabbana to use my name and number for their collection. So in 2019, the Milan court had ordered that Dolce and Gabbana pay €70,000 plus €13,000 in attorney's fee. Now, as a lawyer, that's a good amount for someone to pay for my fees, like €13,000 with our current exchange rate right now. Yeah, so the judge in her ruling stated that Maradona's name is synonymous with football excellence, and that third parties have no right of using it without his consent. Now, Dolce and Gabbana went on about, they were just paying tribute and homage to the star, who is like a hero to so many people in southern Italian city. Right. Why did you not go ahead to get consent, permission, and authorization if you were really paying? Because I'm sure he would have been like, instead of using just the blue and white jersey, why don't you have, let's incorporate me in the show where I'll also appear. I'm sure he would have given them some ideas on what to do, which would have, kind of resonated with the southern Italian city. But then at the how many people from the southern Italian city are actually going to attend that fashion show? But that's an aside right now. Now, moving on, because Diego Maradona is an athlete, a sports athlete, I'm going to kind of share my views that I think athletes can do in order to commercialize and exploit their intellectual property rights. I mean, we have footballers in Nigeria, we have both the male and the female category. How have they been able to actually monetize um, what they do? Because you can't really protect sports, but then the people that actually participate in it can generate revenue when they go into partnerships, collaborations, endorsements, get ambassador deals, create merchandise, etc., etc. So I'm just going to like talk briefly about that. Now, athletes and other stakeholders can key into intellectual property because it is considered to be an intangible asset that you can monetize, just like the tangible assets, where you do that to be able to generate revenue from yourself. And in 2019, I know the World IP Day team was like Reach for Gold, IP and Sports, and it was celebrated globally. So the then DG, who was Francis Gurry, had made emphasis on the role that intellectual property plays in encouraging sports while enriching so many people or stakeholders that participate in the sports industry. I know the most popular sporting event is soccer or football, as the case may be. And there's also this debate about why the male counterparts, the male athletes or footballers are being paid more than the female footballer. That's another discussion for another day. I'm not even going to go into that. But sports, as we know, is a competitive activity that brings teams to play against each other. One person has to win at the end of the day, but then you have to be physically fit. Your health has to be on point because it is your career. It's the way you make money. And you also get to entertain your fans and supporters and help build the club and also put the country in question on the map. I mean, not everyone that plays for a particular club is from that country. So, conversations as to transfer, opening, and the rest of them will definitely come up, working with agents, etc., etc. Now, in Nigeria, when sports is being mentioned or discussed, the most popular of them, other than ball, is track fields and endurance sports, and then the strength and the combat sports. Now, Team Nigeria, I know we are making waves right now with Toby Amuso and Chinyere as well. And Chinyere as well in the Birmingham games. I mean, it's huge. It shows that we are blessed as a country. We have participants in the badminton, the baseball, basketball, chess, handball, hockey, squash, shooting, wrestling, traditional sports, and para sports for disabled people. Now, according to the World Intellectual Property Organization, stakeholders in the sports industry would be the athletes, obviously, the teams and their trainers. I mean, we need to also give kudos to the trainers. I mean, take a good look at Toby and her trainer. They did a fantastic job. And, when you are consistent at something, you're definitely going to achieve the goal you've set for yourself. You may not be the best runner, the world record holder at that point, but when you consistently develop yourself through the help of your trainers and the facilities and infrastructure put in place, you are going to, reach the hallmark that you are gunning for. Then the Sports Federation, also stakeholders in the sporting industry, have the broadcasters and other media platforms. I owe you guys the story about the broadcasting and sporting rights sector and, all of those things for the next 2 episodes and the newsletter to crown it all. The organizers of sporting events, corporate sponsors. Toby, I know I read a post on LinkedIn. Yeah, I think it was on LinkedIn where someone had said Toby couldn't get any corporate sponsors for her to go participate, and that kind of broke my heart. I mean, there are potentials not just for the athlete but also for the corporate sponsor who are also going to be marketing themselves as well. But welcome to Nigeria. Then you have the manufacturers of sports equipment. I think was it last year or last 2 years where it was said that Puma or Nike, one of those big corporate sponsors of a sports event, had donated sports kits to the Nigerian team, and it wasn't distributed. Like, so those issues are there. Then you have the sports fans like you and I who are going to actually sit and watch either the live events in the stadium or on TV via the broadcasting station who have the license, either exclusive or sub license or non-exclusive license to actually broadcast the sporting events. Whichever way you're watching or participating, you are a fan. You're buying the merch, you're buying club kits. I mean, you're going all out as a fan. Yeah. So you're also a stakeholder. You are a stakeholder. Now, how can we then explore the fusion of sports and intellectual property? I'm not deviating from my story, trust me. I'm just like, laying background and laying foundation as to why late Diego Maradona had to go the extra mile, wanted to sue Dolce and Gabbana for using his name and number on the fashion runway. So I'm going to talk about the fusion of sports and IP. Presently in Nigeria, intellectual property is still growing. I know the most popular industry now that are kind of maximizing IP are the entertainment, fashion, film, pharmaceutical manufacturing. But then the sports industry is still struggling. I know we had a launch 2 weeks ago that was like going to make huge wave in the sports industry. So kudos to Madam Kechiobi and her team who were part of that project. But intellectual property and space is still a developing area, not just for the sports industry, but also for intellectual property practitioners, inventors, creators. The government is still trying to understand how important and how useful and the role of intellectual property in the various industry. Hence the reason why we don't have like a proper IP policy that caters to the needs of this industry. I think we need to work on that. I know that some of our IP related laws are being updated and waiting to be passed or assented to, like the copyright bill, the trademark bill, the patent and design bill. We currently have the plant variety bill, but yeah. But as it relates to sports now, we are not doing so much in terms of looking at the commercial aspect and the prospect that intellectual property has when talking about sports and intellectual property. Now, majority of the intellectual property issues are currently settled in the social media era, because just one social media call out and it goes viral and boom, everyone is aware. It's like, oh, so this was happening or that was happening, XYZ, and our courts are not being utilized enough because there are a lot of backlogs in the courts. We do not have IP specialized courts. I hope and I'm praying that is being considered, because presently the Federal High Court heads all intellectual property related dispute. We don't have like a specialized sports dispute court in Nigeria. We do not have that. While the approach of social media callouts could be effective, it kind of downplays the importance of IP. So let's use the instance of when Kelechi Iheanacho was being called out for reposting the image of Puja Media, where he had to crop out or remove the watermark and just repost the picture. Those are issues that if it was taken to court or a specialized IP court or a specialized IP related sports dispute resolution court or panel, we would have had a precedent to work on. And that would have kind of thrown light on the need for sports athletes to start taking issues like this or conversations like this seriously. But we still I know that case kind of pulled in a lot of conversation. I participated in one of the Twitter conversations, and it was a very interesting one. I also ended up doing I think I have a podcast version and a newsletter, still talking about sports, photography, and the rest of it. So yeah, we also need to understand what intellectual property rights are or intellectual property mechanisms are. We also need to understand the fusion of sports and IP, how to make money from sports to intellectual property rights. So our local games that are being played in the different part of the country, which TV station has the license to broadcast those rights? Are the local teams considering merchandising deals for themselves to generate revenue? Are they naming rights for the stadiums that are being used? I know there are issues that we need to tackle, guys. Intellectual property rights are like legal rights that protect creations and invention relating from intellectual property activities in the industry. The most common of intellectual property rights that affect the sporting industry are copyright as relates to broadcasting rights and audio visuals, photography, videos. I know in 2014 there was this case of, resharing or reposting of short videos of live events taking place, and the UK had to update their fair use or exceptions to copyright infringement, something of that nature. We do not review or create laws or regulations or policies or guidelines when we have intellectual property related issues. Like that Kelechi Iheanacho's case would have been a fantastic opportunity to create laws as it affects sports, photography, guidelines for photographers that are participating in sporting events, what is expected. You actually need the consent of the athletes who are actually participating, just kind of things. But nothing was really done, just conversation on Twitter, and it just died down there. So we need to kind of sit up. Then issues with trademark. So Maradona trademark, his number trademark. Then you have rights of publicity where he's monetizing and commercializing. So you want to have like a Diego Maradona, not just a football kit, but you want to have like a collection for that particular season, celebrating his life and time while he was a footballer. All of those things. You could, now that he's late, you can go into a collaboration or partnership with the family who are the heirs and successors of his intellectual property right to monetize that. Then you have trade secrets, that protect confidential information as it relates to the sporting industry, the athletes, and the rest of them. Patents for protection of inventions. So all the kits and equipments and materials used for sporting related events. Design rights are where which protect the visual appearance of what is being created. Then plant variety, which is very tricky. So you just kind of have to be very creative when you're considering that what the species you're going to use to create either the grass that is being used or whatever it is that's going to be used in the sporting related event, all of those things. And in order to do that, we need to understand the fusion of sports and IP. We also need to know the role that IP plays as intellectual property, that intellectual property plays in the sporting industry, how it is relevant to the athletes and their stakeholders, what they need to take note of. I already had given instances like, for inventions, equipments, and the rest of them, the VAR and the rest of them, patents, brands, could be corporate sponsors or the athletes. I know athletes like Jesse Langs. I know Ronaldo has one. I know Messi has as well. I know Messi also had a case, Messi case, designed for the visual appearance and combination of colors, all those things. I think some years back, someone had tagged me to like a Twitter post where two clubs had like similar logos, which was like a combination of colors that were similar or peculiar to those clubs. So those are things you need to consider. Creative works like sports programs, other sports related creative outputs, so that the broadcasting rights and related rights or neighboring rights. Then just to bring to light what I'm talking about in terms of collaboration, I know in 2018 Rwanda went into like a sleeve sponsorship deal with Arsenal, which generated about $88.3 million for their tourism sector. So if you watch the games within that period, you see that Arsenal athletes had visit Rwanda on their sleeves. So that kind of generated revenue for the Rwanda government, and also, gave Arsenal more fans, obviously. Now, how are we missing out on all of these things as the Nigerian sports industry? Rwanda also went into a sponsorship deal with PSG Le Paris the Prince Stadium to sell their tea and coffee for 3 years. So I think you should have elapsed as at last year, since 2018, and this is 2022. Now, bringing it back home, do we have sports athletes or our stakeholders considering intellectual property or even commercializing or exploiting their name, the brand, the logos, etc., and the rest of them? I'm going to give like example of Nigerian athletes who have, done a bit of endorsements and ambassadorship. For instance, we have Osaze Odemigwi, endorsement with Pepsi, Victor Moses with Pepsi, Samsung, Globacom, Michael Obi with Amstel Malta, Kanu Wonkwo, who was a goodwill ambassador for UNICEF, a brand ambassador for Sportsbet and Star Times. He also had the nickname Papilo, and I don't know till date if he ever considered trademarking or if he's been trademarked and if he's been monetizing Papilo. I really do not know, but I expected someone that had that much exposure, having played for Arsenal, would have considered exploiting, elements of his name, just like how the late Diego Maradona was all up in Dolce and Gabbana's ass, and I was like, dude, you guys need to. And I'm suing you guys for €1 million for using my name and number for your runway show, even if you were paying a tribute to me. However, he has that is kind of one. He has a studio that focusing on photography, painting, sound production that is called Papilo Studio. So kudos to him, or thinking about it from the commercial and business aspects. But there are, like I said, no known or existing trademark. I haven't done a search to verify what I'm saying, but yeah. Then you have Alexander Chuka Iwobi. That guy is fine. Okay, he's fine, he's cute. But he has endorsement deals with Nike, LG, Electronics, Multi-Choice, and I think Glow as well, Globacom, I think. Then JJ Okocha has an endorsement deal as well as a brand ambassador deal with BetKing, which is like the second most popular sports betting company in Nigeria. Now, what they have done exclusively is to kind of monetize and exploit their image. So my face on your product is going to generate new brands or new consumers to buy, etc., etc. So there's an aspect of sports and intellectual property right that is still developing, and I hope the Nigerian sporting industry and athletes catch up with that, which is called image rights, which relates to the use of an athlete's persona or brand, and it's considered to be like a valuable asset to both the athlete and the club that he's signed to. Some club kind of like going to an arrangement with the athletes that they're going to actually monetize their name and persona, as the case may be, and which is like called like a face contract, where your face on the product, your face on this, or your face on that. That's another way to generate revenue. Now, a grant of these rights, it's like you're giving access to services of your persona for the purpose of filming, televisioning, both for live and recorded, broadcasting, audio recording, motion picture, video, and electronic pictures that are not limited to the production of computer-generated images or still photographs or personal appearances or product endorsement, advertising in all media formats. Now we have the likes of the metaverse and the NFTs. Those are things that we need to also consider, especially now in this digital era of Web 1.30, video gaming, esports, etc., etc. As well as the right to use your name, likeness, autograph, story, accomplishments, number, including copyright and other intellectual property rights for promotional or commercial purposes that are not limited, without any limitation. So there's no limit as to what they can use with your face, your name, your likeness, but it has to be expressly stated in your contract. So when you get to your contract, please read it, have your lawyer read it, and ground you on what to do. Now in the UK we have what is called the image rights. EU has what is called the personality right, and the US also calls their publicity right. We do not have precedent for image rights in Nigeria, although it's building. Rather, if you're going to sue someone for using your name and likeness, you might want to go using like right to privacy infringement to your right to privacy, but you have to properly couch it and discuss with your lawyer. I mean, we had the case of the Banire last year, which I reviewed, and as well, I was like, I think that should have been a good opportunity for the court to actually set precedent as related to image right. But nah, we've had other cases where RMD, yeah. I was going to make a comment, but I'm not going to do that. But yeah, RMD had his image used by Jumia, which is like an e-commerce platform, and they kind of said, so we need that precedent, and we need to have policies or guidelines for athletes in Nigeria as to how they can protect their face, going to like face contract or endorsement or ambassador deals or image right deals or whatever it is, on how to monetize their name, their likeness, image, etc. Now we have so I'm going to refer to this case, which is like the Michael Jordan against Dominic case, where he had sued the supermarket for using his name and jersey number. You see, kind of links it to our late Diego Maradona case, where he sued Dolce and Gabbana for using his name and jersey number. So Michael Jordan, and I know Michael Jordan is one of the athletes that is really proactive when it comes to protecting his intellectual property. I know he has had a couple of cases in the before the Chinese court and the Japanese courts again, for his Jumpman logo, etc. But this one now is just focusing on his name and jersey number, and he's suing a supermarket. He sued them for $10 million, but was awarded $8.9 million for damages. I'll say that's a good deal. Now, in that case, he said that it was never about the money. I'm not suing you because of the money. Obviously, I'm rich. Yeah, deal with it. But I'm protecting my brand. I mean, he has built his brand over a period of 30-something years, and he wasn't going to let someone take that from him. So you have to be proactive as an athlete. You don't let people take advantage of your name, your face, your likeness, everything about you, and commercializing. Meanwhile, you're not getting a penny. I mean, that narrative needs to change when it comes to the sporting industry, so that our local sports athletes can, have some sort of leverage financially. I don't know if that makes sense. I hope it does, guys. So you can imagine that this case happened in 2015, and this is 2022, or as it then was 2019. That was like 4 years ago, and this is, 7 years later, and I'm still talking about it. So that means a lot has to change when it comes to the sporting industry, how athletes can protect themselves. So Victor Moses and the rest of them, how are they actually protecting their name, the jersey number? You need to take all of that into consideration. I know the famous Cristiano Ronaldo trademark, which is CR7, a combination of his name and his jersey number. So let's start thinking within that line. I'm going to read out what is called the morality clause for you guys, and how it relates to the sporting industry. So morality clause is couched as follows. So it says the sports personality, that is in this case now maybe Diego Maradona or Victor Moses or Michael B. Jordan or Tobi Amusu or any sport athlete, shall at all times during the term of this contract act and conduct himself or herself in accordance with the higher standard of disciplined and professional sporting and personal behavior, and shall not do or say anything or authorize there to be done or said anything which, in the reasonable opinion of the licensor is the person that got the licensor is the person that owns the right, while the licensee is the person that is taking permission to use that right, which could be there. So basically what this morality clause is all about is that you have to be fit and proper. I mean, if you're a lawyer, you understand that, but yeah, you have to behave yourself while you're in a contract with someone, so you don't go and tarnish their image as a brand, or do anything that will be considered to be immoral or not professionally acceptable, that could cause harm to the company or the club or you, or ridicule, whatever the case, or anything that will be disrespectful to their brand. You have to stay away from that. So make sure that you read it and understand it, because you could lose a lot of deals from that, and also tarnish your image and reputation. Now, as an arbitrator, one of the things that we are being told about is that your reputation is your selling point. So imagine you as an athlete, where other than your skills, you don't really have much to, your image rights or your name or likeness. You do something, say you're affiliated to say Nike, and then you do something, and and they're like, oh no, we can't have any of this. Also be very careful about the contract you sign. I know, I think it was Maradona as well. He lost a deal. Is it Maradona? I can't remember, guys. But I know one of these football sports athletes had lost a deal because he had another brand's fizzy drink in front of him while he was signed to another, and he lost that. So then we had the famous brouhaha that took place last year, where Ronaldo had pushed aside the, what's it called now? He had another drink in front of him, and he was like, just water. And the internet wasn't having any of them. Everyone was like, what the hell? Why is he doing that? So it all depends on his contract. So yeah, let's talk about trademark and sports. I had mentioned Jesse Lingard, who has a registered trademark for his nickname G-Lings, and also the image of his goal celebration in class 27. So when you're opting for trademark registration, we have about 45, and you have to pick out of this 45 whether it's for goods or services, whichever one that applies to what you want to use your brand name or logo or symbol or whatever it is called to do. He also had that celebration imagery for clothing line, for footwear, headgear, but not for the performance. So you can't protect the performance of a footballer. You can't do that. Messi also has one of the largest trademark portfolio. He has over 76, as of 2019, he had 76 registered marks, primarily for his name, logo, and signature. Then Neymar Jr. has about 50 registration covering his name and logo. CR7, that's Cristiano Ronaldo, also has CR7, which is used for his clothing line. Then you have instances where host cities for sports events key into trademarking their trademarks at the earliest stage of the preparation. So from the moment they get the contract or get the authorization or get the letter, oh, you're going to be hosting the next sporting event, the first thing they do is trademark their name. So I'll give you instances. We have Tokyo 2020 trademark and the logo, Beijing 2022, Paris 2024, and then LA 2025. Now, intellectual property rights are associated with games protect the integrity and also the uniqueness of the Olympic Games, together with their legacy, and cities interested in hosting such edition go ahead to the first thing they do is register the trademark before the formal process of actually selecting the host cities to begin with. Then innovation in the sports industry, Nike is one of the top patent applicants globally. They currently have 239 sports related patent application. That is between 2014 to 2018. So you can see there are people that are actually thinking ahead, like how do we actually break into this industry. So there are prospects for all stakeholders in the sporting industry. So, in terms of IP protection, it's very important that all the stakeholders continue to think of strategies to generate revenue for the sports industry that will benefit the sports industry, and they'll be able to redistribute them to the sports and the athletes. We also need our stakeholders in Nigeria to start taking the promotion of sports and keying into intellectual property, and also working towards having a proper sport policy, do more sensitization, education, capacity building rather, apologies guys, creating awareness on the issues in the sports industry. And I was recently interviewed by Mr. Jide, who I had a brief conversation as to the interplay of sports and IP. Then my friend Beverly recently had a sports related 2 days event. We started with a cocktail networking session and then 2 days virtual seminar, which was very insightful. We need more of that as well. But yeah, then let's go back to our conversation, our story. So this is so I had then posted Diego Maradona's reaction to the court ruling, and He said, I have been notified from Italy that today the trial ended with Dolce and Gabbana for using my name without my permission. The tributes are fantastic, but I think they should have asked for the necessary permission to use my last name in their parade. A shot for the side of justice. So you see that he is well aware of, the importance of protecting his name. So it's actually his last name that was used, Maradona. He's protecting his last name and his jersey number. He understands how important it is for athletes to start taking commercialization of their work seriously. What are the remedies available when there's an infringement in the sports industry? You have damages. Remember that Michael Jordan had gotten $8.9 million in damages. You have the interim and final injunction. Parties can also opt to explore alternative dispute resolution mechanisms such as mediation, arbitration, negotiation, or hybrid mechanism, or just go to court. Give us precedents that would, the late Diego Maradona had gone to court, hence the reason why they had this precedent where, Dolce and Gabbana had to pay him that money for using his last name and jersey number without his consent. I mean, he understood that the tributes are fantastic in his own words, but then they should have sought permission from him. I think we as Nigerians need to work on having like our own sports tribunal and court. I won't mind sitting. Yeah, then copyright protection, grant you protection as relates to broadcasting and transmitted media formats in TV and radio or podcasts like this, as the case may be. The sale of broadcasting and media rights is like one of the largest sources of revenue for most sports organizations, who in turn use it to finance their major sports events, refurbish the stadiums, and also contribute to the grassroots development of sports. Royalties can be earned from the sale of broadcasting rights to various media outlets. I know I had mentioned how our local league can, key into sale of broadcasting rights to generate revenue. Now, Forbes had as at 2019 estimated that $3.5 billion was gotten from just television broadcasting as a revenue for FIFA between 2015 and 2018. I know that the numbers would have gone up. Then you have sponsorship deals and agreements. Sports teams, athletes, players, organizers can get funding through these means, whereby all parties involved go into a signed agreement to receive funds for either more exposure or anything or more, or whatever the investor is seeking to benefit from it. Then you could also opt for like exclusive licensing, whereby it's just you and one person, or non-exclusive, where you go into an agreement with one or two or multiple persons. So you're generating revenue consistently and getting your royalties being paid to you for a fixed period of time. You as the licensee, that's the person who was given the right, you cannot transfer your right. I know we had that issue where the Nigerian government, as I think that was in 2020 or 2019 as well, I can't remember now, they were like, yes, if you had to sub-license to the likes of NTA, and I did an extensive publication on that on my Twitter blog series, which is like part 2 of the sports and IP conversation that I'll be having over the next 2 to 3 weeks. Then there's merchandising, which is like the commercial exploitation of the person's name. So Diego's name, his logo, emblem, symbol, jersey number, another trademark associated with him. He also, get access to loyalists, fans, consumers who are willing and ready to spend on jerseys, scarves, hats, key rings, whatever it is that was created or produced. Then endorsement is like a combination of both sponsorship and merchandising for the athletes. But yeah, I think that basically covers how you can actually monetize the sporting industry. Then examples of issues faced in the sports industry as a result of digital era will include one, in-venue streaming and broadcasting. That's illegal streaming. One of the issues that comes with being in the digital era. Then you have digital piracy, which is constantly on the rise, and with new technologies and disruptions left, right, center. And now that we have the NFTs, imagine live streaming a game in the metaverse. How mind blowing that is going to be. How does all of these issues affect cross border laws? Because we have different laws that apply or regulate the countries, it's going to be a tough one to actually resolve all of these issues, especially when the person that is doing the illegal piracy, as in terms of illegal streaming, is in another country, say it's in the UK and you are in Nigeria. Which law will govern that dispute when it arises? How will the ISPs, that's the internet service providers, take do their work or enforce whatever laws or regulation they have? Then the unauthorized retransmission of live sports or telecasts over the internet is like one of the main concerns in the sports industry, where broadcasters have lost billions of dollars because of this act. Now, bringing it back home, how do the likes of multi-choice as DSTV and GoTV, with their partnership with SuperSport, how do they cope how do they manage to like cage or limit transmission of sporting events that it can never be live streamed or on the internet? It kind of, at the same time, it kind of limits growth and allow healthy competition, because if we have the likes of multi-choice, doing the TV broadcasting, why don't you give licenses to podcasters or people who like to review live events to have their shows on YouTube or any of the channels or platforms available? And then, regulating in a way that while the competition is healthy, the fees are exclusive. The fees to subscribe, or the subscription model, is exclusive to the participants. So I'm going to pay 20 naira to live stream the ongoing sporting events and the rest of them. Another issue we want to consider is ambush marketing, which takes the approach of passing off. Passing off basically is like you trying to defraud the consumers, the general public, that you are linked to this person, when in reality you are not. You're trying to also benefit from the goodwill and reputation of that person's good or your rival. And when this happens, businesses are trying to bypass sponsorship. So instead of paying sponsorship fee, you want to illegally put your brand name or logo in a place that is visible to participants or fans or athletes and the rest of them. It kind of also limits your chances of getting investment. It damages your investment opportunities, because genuine sports sponsors will not want to be affiliated with such act. And this is called like a guerrilla or parasitic marketing. And in this digital era, social media is like one of the problems that sports industry are actually facing, with infringers and marketers who try to incorporate some elements of their hashtags in their posts. Basically, when that hashtag is viral, just put it, and then when you click on the hashtag, that person's post is part of it. So, for instance, the Olympic or FIFA games, sport brands and tackling counterfeit goods. For instance, again, a typical case would be the Nigerian team football kit for 2018 soccer, which was voted as the best jersey in the World Cup and sold out within hours of release on Nike's website. You found out that there were a lot of pirated copy or counterfeited Nike, because people were like, how will I pay 22,000 or 40,000 naira for a whole Nigerian jersey? So how do you now bring it to the market where people can actually, the real, I don't know if I should say the real fans, but where fans or loyalists can actually buy them so do you now create the original and the counterfeited product, where the people that want the original version, the original jersey, will buy the original jersey, and people that want the counterfeited one or the less expensive one with lesser qualities? I mean, that's something that brands should consider. I know luxury brands have considered that, and that's for like the they've created like a counterfeit of their own bags and sold it out to their consumers, and people actually bought it. So that's something that we need to also consider in terms of tackling counterfeiting products in the sporting industry. Agencies also need to be responsible for checkmating counterfeits. They should not be too focused on taking bribes or not being properly equipped or not meeting the criteria in terms of produce. So you can also go into manufacturing arrangements or licensing agreement or collaboration or partnership with local producers who will be giving the know-how license to actually create a made in Nigerian version of the Nike jersey. Just something to think of and ponder on. Now, on plant variety, remember I talked about plant variety where I said it's a type of IP that is not really common in our jurisdiction, even though our president recently assented aside the Plant Variety Protection Act 2021. Now, this IP protects like independent new species, plant species, or plant varieties or genera that has issues of being distinct, uniform, and novel. They must meet the requirement of having higher quality or resistant to pests and diseases, and increase their market value in the industry. For instance, the turf on the sports pitches is a variety of a plant variety that is protected. For it to be granted protection, if you're thinking of opting for plant variety protection, know that there's a term of duration of 25 years in the case of trees, or 20 years in the case of other crops like vines and the rest of them. The governing act internationally is the Union for the Protection of New Varieties of Plants, UPOV convention. And just like every other intellectual property, it is territorial in nature and also applicable to the states or member states of that organization. Now, looking at privacy issues, if Dolce and Gabbana had approached Maradona, would he have gone ahead to give them license to use his name and jersey number? Maybe, because under our Nigerian Act, Section 37 of the 1999 Constitution gives provision for the protection of the privacy of citizens, their home, correspondence, telephone conversation, etc. Now, also Article 12 of the Universal Declaration of Human Rights provides protection for freedom from interference with privacy, family, home, and correspondence. On the other hand, Maradona ended up getting 70,000 euros for the use of his surname and jersey number without disclosure. So how did Dolce and Gabbana get access to that information? Looking at it also from the data protection aspect of personal data and the rest of them, I know that I had read an article there which listed the following things as that conflict or that kind of do not conform to intellectual property right now. You have the right to access. How did D&G get access to that? And what is the relationship or similarity or differences between the right to access against protection of intellectual property rights? You have right to portability and protection of intellectual property rights, privacy and enforcement of and intellectual property rights. So right to privacy in terms of how can Late Diego Maradona protect his details from the public. I mean, he was a well-known figure. Everybody knew him as Maradona and then the Jersey 10. But whoever has the authorization to keep or retain his data, what right do they have to also monetize it in terms of giving another person the license to do so? How can they enforce the intellectual property right when it's been infringed? Now, to an extent, I know that as at 2019, the GDPR was like the go-to when it came to data protection of personal data and information. But we currently have the Nigerian data protection regulation, which kind of also interfaces with every industry. So just like IP, data protection and personal data are another issue that we should also consider, especially in view of Web 3.0, the metaverse, NFTs, and the rest of them. Now, I will be wrapping up in a couple of minutes, but I hope you guys have been learning something. If you have questions you want to ask me in between, just send me a voice note or voice message on Anchor, and I will listen and give you my response. So like I said, I was going to wrap up because one, we know that, like in summary, intellectual property rights or intellectual property mechanism are territorial. They also give you legal backing and protection and monopoly within that country that you are based in. We need more trainings to be held for the athletes, the stakeholders, the sports event organizers, and the rest of them. Also, the concept of getting consent, permission, authorization should be emphasized on. So people don't take written authorization lightly. You need that written authorization or license agreement from the owner. Then we also don't need to fall victim or pay damages. Instead, we need to consider the option of collaborating or going into partnership, because the sporting industry is like a big business and worth more than 3% of the world trade. So if you have this industry that contributes about 3% of its, of its own due to the world trade. Imagine if we do the work in terms of educating ourselves and positioning ourselves and having the right infrastructure in place, how we're going to increase that percentage. So yeah, I hope we've learned if there's one thing I want us to take, is that you can't use the name or jersey number of a well-known athlete. I mean, it's fun to wear jerseys or buy jerseys, but doing that, make sure that you're not interrupting or trying to monetize or commercialize or take advantage of another person's goodwill and reputation at the end of this. So yeah, thank you guys for listening to me. So thank you guys for listening to me. Don't forget to check out my previous episode and listen to this episode, like, share, let me know your thoughts, and I hope to see you guys in episode 73. And cheers guys, have a fantastic week.